Hi, I'm Vicki Roberts with Bloomberg Law. I'm here in Phoenix at the Littler Executive Employer Conference, and this is Alexis Knapp. She is a shareholder with Littler, and Alexis and I are going to talk today about developments in the intersection between FMLA and ADA. It's a very tricky area. We get questions about it all the time. I'm sure you get questions about it all the time. So most recently in the news, the Supreme Court denied cert in a case called Severson v. Heartland Woodcraft about a month ago, and that had to do with this intersection between FMLA and ADA. So can you tell us a little bit about that, and what is the impact? What does it mean?
Absolutely, thanks Vicki. I think for a long time we worked on getting FMLA right, and it took us time to sort of figure that out. And then once we got FMLA right, we thought we were done with the leave question. But the EEOC has long maintained, and the court has always reinforced, that leave is also one form of reasonable accommodation under the ADA. Now that could look a lot of different ways. It's not exactly like FMLA, but it could be a reasonable accommodation for someone to be gone a little bit longer, to have a reduced schedule, those sorts of things. And even though the framework is different for who gets it and who doesn't, the reality is we have to at least have the conversation. That has been the law for a long time. I think we've seen developing cases on it more recently. Severson was actually a big win for employers in 2017, and it took the position that the ADA actually is not a leave entitlement. That's not what the statute says. And so on the particular facts of that case, the court felt like the employer didn't have to provide an extra 3 months of leave beyond FMLA. And then in denying cert, that case sort of stood as the current state of the law in the Seventh Circuit. Certainly, some circuits have taken different views on how much leave is too much and when we get to say no. But I think the really important thing for employers to keep in mind, and really lawyers on both sides of the bar, is that what Severson said was still a fact-specific ruling. There is some good language for employers in there about the ADA not being a leave entitlement, but the reality is that on those facts, the Severson case went the way of the employer. The EEOC still very much takes the position that it is a leave statute. It's also, a different equipment statute and a different schedule statute. It could be any of those things. And so Severson is not a free pass, but it's really good case for employers in the Seventh Circuit. But I do think it continues to illustrate that we have to at least have the conversation. Whether we win or lose in litigation, as an employer, might be a different question than how we fare at the EEOC or the administrative stage or under a particular state law.
Okay, well, speaking of the EEOC, do you see any changes coming ahead from the various agencies that have their hands in this issue?
I think the EEOC has been very consistent about their position on leave as an accommodation. They absolutely believe and have reinforced that it's a conversation that needs to happen. It has continued to be part of their strategic enforcement initiatives, and they've continued to enforce and file cases on the leave issue under the ADA. I don't think their position on that is changing. Certainly the Department of Labor continues to do FMLA investigations and so on as they did before. There's been a lot of talk about how these agencies are going to function under President Trump as opposed to how they functioned under President Obama. And I think some of it's been a lot of sort of myth and legend. I think the reality of it is the guiding principles that have controlled leave are still the same. I think there's a question about how big and how aggressive and how much money these agencies will have under the new administration moving forward. But I think we still need to expect that their enforcement positions are unchanged on the leave issue.
Okay. Well, we've talked about federal courts, federal agencies. Let's hit the state and local arena. How about the state and local laws? How much of an effect do they have on this intersection of ADA and FMLA, or how much effect do they not have at all?
10 years ago, my answer on this would have been very, very different. The FMLA was still sort of the beast, right? If you were complying with federal FMLA, the odds were those states that had what we call mini FMLAs were probably being satisfied. Similar to the ADA, once the ADA was amended and it expanded so much, the general sense was, okay, if we're complying with federal ADA and we're doing a really good job, we're probably hitting the mark at state level. I think in the last several years that's changed dramatically. And this is not an Obama-Trump thing. This is a state level, grassroots, bottom-up sort of movement where the states and even local legislatures and city councils and so on have reached into the mix and they've tried to fill gaps that they think are left by federal law or even their state laws in some circumstances. So I don't know what number we're on now. I would say more than 40 probably probably local and state level paid sick leave ordinances and laws that lay on top of FMLA and ADA that might provide enhanced protections, pay, additional time off, benefits protections, things where maybe the ADA doesn't require it, but the paid state, or the state paid leave does. And so I think it's not enough just to do a federal analysis and say federal law is hard, and if we're doing that, we're making the states happy, because I think the activity in the state and local level is making that a big deal. So you have things like mandatory paid sick leave at various levels within a state and local government. You have things like leaves for other reasons, domestic violence victims leave, crime victims leave, all kinds of leaves that are out there, bone marrow and organ donation leaves, firefighter emergency leaves. I mean, for a multi-state employer, they have to have a multi-state resource. And just relying on internal HR, that's expecting a lot. These state laws are getting tough to navigate. So you can't have an FMLA or an ADA discussion without at least saying, where does this employee work? And is there anything more difficult about that jurisdiction?
Okay, it's a lot to keep up with. Do you see any more trends coming down the pike in this area?
I think probably the one trend as a defense practitioner, I think the one thing that I see that makes me the most nervous is sort of the demand on an employer to recognize that one of these conversations needs to take place. I see more and more notice cases and more cases about, should you have known as the employer that there was a leave or accommodation issue, and did you miss it? Did our managers miss it? Did our supervisors miss it? 10 years ago, we sort of expected people to come in and say, I need FMLA, or I need an accommodation. And the case law is very clear, and the agency enforcement positions are very clear. They don't have to even know what those things are. We're supposed to listen for cues to start those discussions because we're the employer. We're supposed to know. And if an employee doesn't know, they can't be placed with that burden. So we don't have to give somebody a roadmap if it's not a sincere need, but somewhere between not letting them abuse an employer and being kind and compassionate is where we need to land.
Okay. All right, well, thank you very much.
You're welcome.
And thank you all for joining us.
Thanks.